And this is the PPT on the case laws. So presently I have covered only Supreme Court and High Court. I think now it is visible on your screen. I'll put it in slideshow mode. Now it is better, I think. So, innovative industries. So what I will do, I will cover the case laws which you have already read in a faster way, so that we can devote more time to the case laws which are new. Innovative, you all know, this is a case law on supremacy of IBC over other laws. Section 238. So section 238 says that non-obstante clause, notwithstanding anything contained in any other act or law for the time being. So this was the case where the loan facility was availed from ICICI Bank and there was restructuring. This loan was pending even prior to this IBC. But when IBC came, so ICICI Bank filed a petition under section 7. This company was situated in Maharashtra, Innovative Industries, and this is one of the first cases in IBC. So in Maharashtra, there is a Maharashtra Relief Undertaking Special Provisions Act, which says that if a company is in some financial crisis, so then there is a period of moratorium and you cannot insist for payment during that moratorium period. So it was something similar to IBC, and that act also contained a non-obstante clause. This Maharashtra Relief Undertakings Act is basically a labor welfare legislation which tends to protect the interests of the workers, because they are of the view that if payment is insisted from a company which is already under financial crisis, then it might lead to closure of the unit and then consequential unemployment. That was the logic. Second point here was whether the appeal filed by the erstwhile directors on behalf of the company is maintainable, because this company was into CIRP. CIRP was admitted against the company and the appeal was filed by erstwhile directors. So this question was also there as you know, under IBC, the powers of the board get suspended, and whether the erstwhile directors, which now stand suspended consequent upon CIRP initiation, so whether they can file an appeal or not. This was also one of the questions, but Supreme Court said, okay, nothing doing. This is one of the first cases, so we are not we are ignoring this point, although they are not entitled to file an application. Second point was whether the appellant's vested right under Maharashtra Relief Undertakings Act can be interfered with by the insolvency, because that act also contains a non-obstante clause, but that is a state legislation and this is a central legislation, IBC. And then there was a question of repugnancy of this Maharashtra Relief Undertakings Act with IBC. And the rule of repugnancy says that, okay, if there is a state legislation and there is a central legislation, then the state legislation must give way to the central legislation. So the Supreme Court found substance in the plea taken on behalf of the ICICI Bank that the present appeal at the behest of the erstwhile directors is not maintainable. According to Supreme Court, once an insolvency resolution is appointed to manage the company, the erstwhile directors who are no longer in management obviously cannot maintain an appeal on behalf of the company. So in this present case, this being the first case, the present appeal is obviously not maintainable. However, the Supreme Court refused to dismiss the appeal on this aspect because it noted that this was the first application that was moved to the court. And it considered it necessary to deliver a detailed judgment so that all courts and tribunals may take notice of a paradigm shift in law. Now, what was the decision? So it says the scheme of the code is to ensure that when a default takes place, in the sense that a debt becomes due and is not paid, the insolvency resolution process begins. Now, when it comes to financial creditor, because as we know, financial creditor, operational creditor, or the corporate debtor itself can initiate the CIRP process. So when it is initiated by an FC, so section 7 becomes relevant, and it says that under the explanation to section 7.1, a default is in respect of a financial debt owed to any financial creditor of the corporate debtor, and it need not be a debt owed to the applicant to financial creditor. So we are very well aware that under section 7, the application, whosoever is filing the application, it need not be that the default is to that person only. Default could be of someone else also. The concept of locus standi does not apply in case of section 7 application. Now, repugnancy, regarding repugnancy, it means the direct collision with each other of different acts, reaching a situation where it is impossible to obey the one without disobeying the other. So this happens when two enactments produce different legal results when applied to the same facts. So in this case, the rule of repugnancy says that whenever there is a state legislation and a central legislation, so the state legislation must give way to the central legislation. So Supreme Court also was of the view that the tribunal was correct in appreciating that there would be repugnancy between the provisions of two enactments.